The language of birthright citizenship comes from a black man, Martin Delaney, 1852. My name is Rashaya. I teach equal protection courses. I teach courses on the 14th Amendment. I teach courses on the Constitution. I teach courses on race. I teach courses on First Amendment speech and press. So this is absolutely my area. And I think people don't understand because you don't spend time with the congressional record and the newspaper articles at the time and what, the president was writing and saying at the time. But when I tell you that the 14th Amendment, the Reconstruction Amendment is really writ large. Let's say it's synonymous with blackness. The things we talk about in the law and in scholarship is a way that race isn't just an attribute of people. Race is an attribute of space. Race is an attribute of all kinds of things, including the law. And the 14th Amendment in particular is racialized as black. Yes, it's been expanded. Yes, it applies to a myriad of other groups. And right now, the focus is on undocumented people. But I want you to understand the actual ethos, the essence of the amendment is racialized as black. And that's partially because the language of birthright citizenship came from a black man. In fact, a lot of the language of the Reconstruction Amendments came from black people. Although there were about 4 million black people enslaved at the start of the Civil War, there were about 500,000 free black people. Right, about 500,000 throughout the northern states. And they would hold colored people conventions. They'd hold their own intellectual spaces. They wrote their own op-eds, if you will. They wrote their own articles. They had their own speeches. They had their own view of what the Constitution meant and how it should be interpreted to include black people in the polity. And the language, the term, the phrase, birthright citizenship was one introduced by a black man into that political discourse. And so a lot of the language of the Reconstruction Amendments grows out of those abolitionist colored people convention efforts where black people were interpreting the Constitution for themselves, were advocating for the Constitution for themselves. And that's partially what created the vitriol, the strident backlash to the amendments, because how dare black people have the ability to influence the Constitution? There's a senator from Kentucky who gives a speech on the congressional floor, 1864. His name is Garrett Davis, and he goes through, it's a 16-page congressional speech. You can find it on Cornell Law Library's website, but he basically goes through and explains why black people are not part of the polity, why they shouldn't be considered. People are upset about that UF student, that University of Florida student who got that award for saying that the Constitution is for white people. Dude might be on some other shit, but he's not wrong. Like, his intentions might not be pure. But the point he's making about the Constitution not contemplating black people and not having our humanity and our well-being in mind when it was drafted is correct. And it was a point that the folks who were in opposition to the Reconstruction Amendments harped on during the Reconstruction period, during the period of the Civil War. And so the impetus, the opposition to these amendments has always been an integral part of the story of how they're interpreted, of how they're enforced, of who gets to wield them, of who get access. These things are inherently animated by white supremacist backlash. There's a great article, if you're still interested in this, called Our Constitutionalism of Force, Farrah Peterson. I think she's at Yale. And she talks about how violence is part of our constitutional interpretative regime, our traditions. And one of the ways she talks about it is because of how violent people were once these Reconstruction Amendments were passed, and how that violence shaped Supreme Court interpretation and shaped how courts dealt with these amendments. So when I tell you, Big V, my mutual, hey girl, I see you. She talked about how, like, y'all don't understand how this animosity to the 14th Amendment, animosity to the Reconstruction Amendments, how President Trump called us slaves and not black people, has been building since Reconstruction, and she is absolutely correct. She is absolutely correct. The vitriol, the backlash that we are seeing play out right now, that's being laundered under the guise of getting the undocumented out, has existed since Reconstruction. It has been fueled by anti-blackness. It has been fueled by white supremacy. Now, granted, because white supremacy, anti-blackness is the framework, it's deployed against any non-white body in violent ways. So it absolutely gets to other non-white people, especially as the amendment was read more expansively to include groups that weren't part of enslavement. But make no mistake, this is a resurgence, a reassertion of white supremacy and anti-blackness. It is absolutely about undoing the gains of the civil rights movement. That's why they attacked the voting rights. That's why they attacked affirmative action. That's why they attacked. You see what I'm saying? This is absolutely about the backlash. This is a project. This is a long game project that is attempting to erode the gains of the civil rights movement and the gains of the Civil War. And they can, and they're making mollifying black people. They're making us passive right now by saying, oh, it's not you guys, it's them. But you need to understand that this doesn't come from just anti-immigrant hostility. This doesn't just come from the fact that Hispanics aren't Anglo. This comes from a deep, deep, deep understanding that this country's value is inherently tethered to whiteness, and whiteness's value is inherently tethered to the subjugation of the people with the least proximity to them, and that's us. It's anti-blackness. Don't let them tell you that eroding the 14th Amendment or any of the other Reconstruction Amendments, including the voting rights one, is about somebody else. It's about you, babes. And unfortunately, and Scott Galloway is having this conversation, and Big V said the same thing. That's how I know that there's truth and value, because you're hearing it from completely different sectors of the globe. From Scott Galloway is a business professor at NYU. He is a bald-headed white man. Big V is a black woman organizer in Chicago, and they saying the same thing within the same week to different audiences, right? These kinds of things are self-correcting, but they're self-correcting through revolution, war, famine. And so for anybody who's thinking we about to vote our way out of where we are, baby, message me so we can talk about some historical context.
Florida at it again. A white nationalist at the University of Florida, they decided to give this dude a law school award for his essay. His essay, by the way, was arguing that the Constitution should only serve white people. Like it's only for white people. And they thought, this is a great essay. Award. What? But at the same time, critical race theory can't teach it. Can't put it anywhere. This, I'm going to give you an award for. But critical race theory, get rid of that. Maya Angelou, get rid of that. You can't put anything in it. Get rid of all of it. Anything that pertains to slavery, race, black people, Hispanic people, all that. We want all that out of there. But this guy, for your paper, talking about how white people should be the only people allowed to vote, I'm going to give you an award for that. Go ahead. Look it up. True story.
So they absolutely don't consider the 14th Amendment legitimate for two reasons. Reason number one, I already told y'all, is because they borrow language. The 14th Amendment borrows language from black writers, black thinkers, and black speakers at the time, which was an affront to white supremacy. But the even bigger affront to white supremacy was that they needed black people in order to get it passed. The 14th Amendment is the first time black people got to participate in creating the Constitution for their benefit. It's the first time black voices were directly involved in the creation of the Constitution. That's the biggest reason they're going to consider it legitimate, right? So you got to remember that less than a week after the Civil War, Lincoln is killed. And so Andrew Johnson immediately comes to power. Now, Andrew Johnson was always very anti-slave owner, but you have to understand him to know and get the nuance of what's really happening here. He's anti-slave owner because he himself is a poor white, and he doesn't have wealth. He doesn't have political influence, and he resents being treated like a pauper. And so after the Civil War, he ascends to the presidency. This is his time to get back. This is his time to get even. And just like a wounded little child, what does he do? He makes all those planters come to the White House, basically kiss the ring. Like, yeah, dog, you used to hate on me, used to shit on me when you had all that money. You thought I was nobody. Look at me now. I'm the president, bitch. You ain't getting back in the union unless you come kiss the ring, bitch. Right? So Andrew Johnson feeling himself. So sure enough, all the planters go to the White House, kiss the ring. Now he's super pro-planter. So he reinstalls basically the Confederate governments in the South. He lets them basically take over immediately after the Civil War. It's not until Congress rejects Johnson's Reconstruction plan. I know y'all just way more history than y'all want to know, but hopefully it's helpful. Congress rejects Johnson's Reconstruction plan and basically puts the South under military rule. And when the South is under military rule, then you get your biracial governments. That's when you have black people. Black people are elected to basically 1,500 offices throughout the United States. You get black people in positions of political power. It's the black people who ratify the 14th Amendment because they tried to get it ratified under Andrew Johnson's conservative Confederate governments, and they all reject the 14th Amendment as an affront to white supremacy. Then once the biracial governments are installed, that's when the 14th Amendment gets ratified. And so it's considered illegitimate both because it borrows directly from black thought at the time, and then secondly because it's the first time black people are directly participating. There were some black people who voted for the ratification of the Constitution at the nation's founding, but the Constitution didn't reflect their interests. The 14th Amendment is the first time black people vote for the Constitution that directly reflects their interests. If you're interested in learning more about this, there's a great book I recommend called The Second Founding by Eric Foner. He's considered kind of the leading scholar of this era. I think he's at Yale or Princeton. I'm going to read to you his quote verbatim on this. "Here indeed is a profound irony. The framers of the 14th Amendment studiously avoided including black suffrage among its provisions. But without the votes of black men in the Southern elections and Southern legislatures, the amendment could never have become part of the Constitution. If you can't connect the significance of that to an administration that's attacking black thought in the form of attacking critical race theory, attacking black language and terminology in the form of attacking woke, right? And think about the language being borrowed from black thinkers being put here, and think about the attack on black thinkers, on black language, on black programs like DEI and affirmative action. If you can't connect these things, even if just the symbolic, the optics of it in terms of attacking, if you don't understand the through line, child, I don't know what to tell you. I'm to believe you missing one of the three C's: context, critical thought, or common sense. And I just want to give you just another example of why this whole discourse about we don't have to worry about other people don't make sense. So 15th Amendment's language, right? The 15th Amendment says you cannot prevent people from voting based on color or previous condition of servitude, right? It has what we call in the law a prohibition, right? It's a negative law. So there's negative law and positive law. It's in positive laws when someone gives you an affirmative right. You have the right to vote. The 15th Amendment's language could say all men have the right to vote. It does not say that. Do you know why it doesn't say that? You know why it says that the access to the ballot can't be prohibited on basis of race, color, or previous condition of servitude instead of just saying all men have the right to vote? Using poll taxes and literacy tests already on the East Coast and on the West Coast to stop Chinese and Irish immigrants from voting. And so when they were having the discussion about how to frame the 15th Amendment, because after they realized that they wasn't going to be able to, well, one, Republicans would have no political power in the South, but two, they'd never get control of the South, that the Civil War's ends weren't secure without giving black people to vote. They were like, we have to figure out how to codify this. And so they were debating back and forth. Should we just say all men have the right to vote, or should we say you can't abridge the right to vote based on color and race? And the reason they decided on the latter is because they wanted to make sure that their state still had the right to stop Irish and Chinese immigrants from voting using poll taxes and literacy tests. And if they had said every person has the right to vote, every citizen, every man has the right to vote within your state, every man who's domiciled and established residency in your state has the right to vote, they knew that they could not have then stopped the Irish immigrants and the Chinese immigrants from voting. And so they thought, what we're going to do is we're going to just fix it for black people. And the rest of these groups we won't worry about because they're not who the amendments are for. Kicker is that because they didn't deal with the discrimination against immigrants, those same tactics were immediately employed to disenfranchise black people. And since that time, through gerrymandering, through voter suppression IDs, all of which could have potentially been avoided had the law just said all men have the right to vote. Because they didn't put that in and they tried to just fix it for black folks, because they thought that they could fix it for black folks and still discriminate against immigrants, we still fighting for our right to vote. We still, our voting ability is still a constant fight, as evidenced by Shelby County v. Holder, which just happened in 2017, and the Brookings report that happened last year or 2 years ago, where they were like, yo, electoral manipulation is out of control. Or where they had to reverse how one of the Carolinas gerrymandered their voting by saying it was precision. They gerrymandered it to precision to exclude black people. We still fighting for our votes because we didn't address discrimination writ large. Because the reality is that you cannot fix it for one group if you don't fix it for everyone. We didn't get our opportunity to continue. Imagine how much differently we could have shaped the country had we really been able to vote in the century between the Civil War and the Civil Rights Movement, had we just fixed the thing that they thought was only going to keep out Irish and Chinese immigrants. The idea that you can fix one part of subjugation and leave the rest of it intact and it not affect the people you think you fixed it for has been disproven time and time and time again. The last time people assumed we could do it for black people, that black people was safe as long as we only attacked immigrants, we were wrong. And we've been dealing with the fallout and the consequences of that ever since. And I'm not saying you have to get out and vote, or you have to get out and protest, or you have to get out and do any particular thing. But you do need to be cultivating some kind of resistance, whether you in the streets or in your house having private meetings. But the fact that you can do nothing is not correct.
The United States government is starting to prepare to take citizenship away from people. This is not an entirely new phenomenon called denaturalization, but we are about to see a ramp up in this process and procedure like we have never seen before. And it is particularly dangerous because of the approach that they're going to use. The Department of Justice has announced that it intends to ramp up its denaturalization procedures to try to find and take away the citizenship of certain immigrants in the United States of America. This, as we know, and we have seen with every other act of the administration, is going to start small and then grow exponentially. Revoking citizenship is a core constitutional concern. In fact, there's a case from 1958, and one of the most famous quotes from that is, "Citizenship is not a license that expires upon misbehavior." But this administration and this Department of Justice are about to ramp up a large-scale attempt to denaturalize people who are not naturally born citizens, and remove and revoke their citizenship and ostensibly deport them. Now, this is largely because their immigration efforts and deportation efforts have failed, and they have failed to meet their consistently unrealistically high deportation targets. And so it's easier to go after people who have criminal histories because they can find them, they can denaturalize them, and they can deport them. But the line between taking away a naturalized citizenship and taking away a natural-born citizenship is a straight line. And if you don't think that it can come for you, you are wrong. And history tells us this. And of course, before we review that, let us not forget that they are fundamentally attacking the idea of what it means to be a natural-born citizen via birthright citizenship. The core fundamental right of your citizenship is only guaranteed because you think it is guaranteed and because there has never been an attempt in the past to take it away. But in Germany, in the 30s and 40s, this was one of the first things that they did to chill political dissent. In 1933, they passed the Enabling Act in Germany, which allowed them to pass laws that specifically violated the Constitution. They systematically downgraded or changed citizenship status across Germany for people who they deemed unworthy of loyal citizenship. The Enabling Act allowed Germany to pass laws which violated the Constitution, and some of those laws allowed them to fundamentally change and take away citizenship, and they used this as a weapon to attack critics of the government. And in the United States, the Department of Justice is choosing a particularly pernicious way to do this. They're taking denaturalization to civil court, which means if your citizenship is challenged by this government, you are fundamentally not guaranteed a lawyer. You are not guaranteed a lawyer in a civil proceeding. So the government can try to take away your citizenship, and if you cannot afford a lawyer, you are going to have a very difficult time challenging that. Regardless of your thoughts on this government is fundamentally trying to change the definition of what it means to be a citizen. And they are making the loyalty test loyalty to this administration, which is something we all must resist.